So good evening, everyone. Thanks for joining in today on a Sunday. So pleasure to have you all participants joining in for today's session. Today we'll be taking over. I'll be taking the session now, and we'll be discussing the remaining part of the permanent establishment, which was left out yesterday, and then we will be moving on to the Article 7, wherein the provisions of taxation, how to tax a permanent establishment. Say, for example, but permanent establishment has been created. Now what? How it is going to be taxed? So we'll see that. Now, in Article 5, what we will cover today is basically the agency P, which was not discussed in detail yesterday, the exclusions from the definition of PE. Then Article 5.7, there is a very small and important paragraph of Article 5, which says that independent entity should not be taxed, should not be considered as P. Then we'll move on to Article 7, which is about taxation of PE, rule of force of attraction, which we discussed briefly yesterday. Now today we will be discussing it in detail. Then what are the deductions allowed in while computing the taxable income? How is it to be calculated? It is to be, so there are other aspects of Article 7 which we will be discussing today. So let's just summarize once of the discussion which was held yesterday. We discussed PE. PE Article 5 para 1 was the basic definition of the permanent establishment, which says that if there is a permanent physical place of business wherein your duration test is satisfied, wherein your disposal test is satisfied, wherein your business activities are being carried from, then the same shall be treated as a permanent establishment. Then Article 5.2, there were certain list of places which were deemed to be considered as PE. So for example, branch, office, place of management, there your any quarry, any oil and gas field, and so forth. There were certain things which were listed out in Article 5.2. Then there were clauses of specific installation and commissioning P. Your building site can be a P. Your supervisory activities can be considered as a P if the same are continued for a relatively long period of time as defined in the various treaties. There are different thresholds for different kind of activities to be carried on the source state. So that was the commissioning installation P, which we call generally. And installation P generally in itself includes supervisory P, your building P, and all those things. Then we also discussed service P, which is not constituted through a place of business, but through employees or other personnel deputed to a source country, through which services are provided to the customers based out of the source country. So there were also discussion regarding the solar days and man days, difference between solar days and man days, and it is the solar days which are counted and not the man days. So for example, if three persons are present on in the source country for one day, then it will not be counted as 3 days, 3 man days, but it will be counted as one solar day. So there were discussions about how and where the lien of the employment matters and what are the precautions which we can take in drafting the agreements and drafting the secondment arrangement so as to mitigate the risk of service PE. Now, another important part of the PE is, which is generally found the most prevalent and which is the most fought for and alleged kind of a PE. This is the agency PE. Now we'll discuss what is an agency PE. So let's envisage the situation that there is a foreign supplier, foreign seller of goods. They want to sell goods in the country S, and they appoint an agent which will go out in the market and solicit clients, and they will seek business from the customers in a source country. In this kind of a situation, the goods are supplied directly to the buyers. The agent does not act as a importing agent. They are not importing the goods in their own name, but the goods are imported directly in the name of the customers. The agent only acts as a service provider. So the question arises whether in this kind of situation there can be a PE or not. So anybody who would like to answer that, whether there can be a PE and how? Just a brief.
Anybody interested? I think
Okay.
Sanjay ji. Okay, Anshul, continue.
No, not an issue.
Okay.
So there are certain conditions and circumstances under which this agent can be considered to be constituting a permanent establishment of the seller in the country S, which is the country of source of income. So what are those conditions and how it is defined? What are those parameters basis which agency P can be considered to be existing in the source country? That is what we are going to discuss in this particular phrase, agency P. So generally agency P is described in Article 5.5, paragraph 5 of Article 5 in OECD Model Convention. And the text, I'll just read out the text once. Notwithstanding the provisions of paragraph 1 and 2. So please note that it is a non-obstante clause, notwithstanding anything contained in paragraph 1 and 2, means the physical presence test, the physical place of business test, the disposal test, all those tests will not be material enough to determine the existence of agency P. Then where a person other than an agent of an independent status. So we'll discuss what is an agent of an independent status, and whosoever agent is not an agent of independent status will become a dependent agent. So please understand that dependent agent is not defined in the treaty, but independent agent is a concept which is provided for, and whosoever agent is not independent, he will automatically be qualified as dependent agent. Now, other than an agent of an independent status to whom paragraph 6 applies, is acting on behalf of an enterprise and has and habitually exercises in a contracting state an authority to conclude contracts in the name of the enterprise. Means the agent should be there, then there should be an authority to conclude contracts, and he is habitually concluding contracts. That enterprise shall be deemed to have a permanent establishment in that state in respect of activities which that person means the agent, that person undertakes for the enterprise. Enterprise means the foreign enterprise who is located outside of India and performing activities through the agent in India, unless the activities of such persons are limited to those mentioned in paragraph 4, which if exercised through a fixed place of business would not make this fixed place of business a permanent establishment under the provisions of that paragraph. Paragraph 4 is the paragraph of exclusions. There are certain items which have been listed that if a foreign enterprise is doing these kind of activities through a fixed place of business, in that particular case, there will be no PE. So we will be discussing the exclusions after the agency P. Even though the article of exclusions is prior to Article 5, para 5, but we will be discussing this after agency P because first we will conclude all the types of P. Now, what is paragraph 6? Paragraph 6 says an enterprise shall not be deemed to have a permanent establishment in a contracting state merely because it carries on business in that state through a broker, general commission agent, or any agent of an independent status. See here, it says that agent of an independent status, and also it is again coincided with another condition that provided that such persons are acting in the normal course of their business. So it should not be happening that people are independent, but they are being used as conduit. May I request all the participants to mute themselves, please?
Request you please mute yourself.
So we'll discuss this in detail. Now, what each and every word and phrase in this particular definition carries meaning, and therefore it is very important to understand each and every phrase of the definition. So first of all, we looked at that he has and habitually exercises. So first of all, has and habitually exercises means that the act of authority of concluding the contracts must be repeated. It must not be a single isolated contract which a person has executed for the foreign enterprise. That might not be considered as creating an agency P exposure to the foreign enterprise. But yes, if an agent has been appointed who has been granted to who has, first of all, has means he has the authority, and then he habitually exercises that authority also to conclude contracts. So the authority to conclude contracts, what does authority means? Authority means that the agent is capable of finalizing the terms of the contract with the customers without going back again and again to the foreign enterprise. Means, say for example, the foreign enterprises has given certain freedom to the agent that within these parameters you are free to conclude the contract. Say for example, you are free to decide the price up till and within this particular band of prices. Say equipments are to be sold from a foreign enterprise to the Indian customers, and the price of the equipment is fixed at 10 lakh rupees. So the agent might have been given some certain authority that okay, you can give a discount of up to 20% without coming back to us, or you can decide on the delivery terms or the shipping terms or the cost of the freight. All those kinds of little bit of terms here and there can be decided by the agent on his own without going back to the foreign enterprise, foreign principal time and again. That means that there is a certain authority which has been given to the agent to conclude the contracts. Now this is some way which is very widely used as a counter argument also, wherein the agent is appointed in India. You would maximum time see that the foreign companies have set up their subsidiary companies in India which are acting as marketing agents, and they are going to the customers also explaining the features of the equipments or the goods which they are selling, their foreign company is selling. And in that particular scenario, what happens is, what generally is taken as a precaution, that they do not finalize the terms of the contract, even though there are certain few parameters which they can agree upon, but they will always mention to the client that we will go back to our parent client company and agree with the terms with them, and then only we can say okay to you. Even this hygiene needs to be maintained in the communication, the verbal or the written communication which is happening between the parent company and the subsidiary company, which can be alleged as an agent. And in those circumstances, the taxpayers generally say that because we are not having an authority to conclude contract, we are merely acting as a communication channel between the parent company and the customers. Therefore, we should not be considered to be an agent in who is having the authority to conclude contracts. So therefore, this is very important. And whenever you are analyzing any facts of the case, this phrase is very important to be considered. Then there is also one thing, that even if the agent is considered to be an independent agent, we'll discuss what is an independent agent. Agent can be independent in terms of legal independence as well as in the terms of economic independence. So once an agent has been considered to be an independent agent, then what? Even in those circumstances, if the agent is not acting in the normal course of his business, say for example, the agent is not in the distribution business, they are service providers, but they become agent just as a conduit for the foreign company to solicit customers in India. Even in those circumstances, there can be allegations from the income tax authority that independent agent is not acting in the ordinary course of their business, and therefore they should not be considered as independent per se. Now, what does this mean? That we have to see all these conditions to be cumulatively satisfied to arrive at a position whether there is an agency P or not. Now, the last point is, an agent predominantly acting for one enterprise would be economically dependent on the latter. What does this mean? Say for example, if I am a subsidiary company of my parent company and I am acting almost wholly, 99% of my business is coming from my parent company only, and I am acting as an agent for this company only. So therefore, I am economically dependent on my parent company. I don't have any other source of income. I don't have any other stream of income through independent clients. Therefore, if today the parent company decides not to do business in India, then the business of agent, the subsidiary company, will come to a halt. Therefore, this is called economic dependence. Then there can be legal dependence also, wherein you are legally bound to do certain things for the parent company. This is called legal dependence. So we understood that once we have to determine whether there is an agency P or not, we have to see whether the agent is a dependent agent or not, whether he has the authority to conclude contracts, and even if he has the authority, whether that agent is habitually exercising that authority to conclude contracts in in the source country or not. Once that happens, then you can say that there is a agency P. Now, there are different aspects of agency P also. Different treaties cover different kinds of activities to be undertaken by the dependent agent. Say, for example, in UN Model Convention, we studied OECD model. OECD model is very short in its sense. It does not cover a wide range of activities. But if you would see UN Model Convention, it is a very wide definition. So we'll read it once. It also starts again with the notwithstanding clause.
Which is widely followed, UN or OECD model convention in this
India
matter?
generally follows UN model.
Okay.
And if you would see the business connection, which is in section 9 in Income Tax Act, that is also generally, drafted on the basis of this particular UN model only. So even for the countries where we do not have treaties, in the business connection, the definition was amended a few years back, 5 or 6 years back, wherein the agency P concept was brought into the Indian Income Tax Act also. What happened sometimes was, in some cases it happened that agency P is a concept in the definition of permanent establishment in the treaty, but there was no corresponding provision in the Income Tax Act. So many times the taxpayers were arguing that there is no agency P provision in the Domestic Tax Act. So how can you create a P just on the basis of the definition provided in the treaty? We'll opt for the beneficial provisions, and therefore, because there is no concept of agency P in the business connection definition of Income Tax Act, we do not constitute any P because of the agent. So that is why the Indian authorities also thought that we should amend the section, and therefore section 5 was amended. Section 9 was amended at that point of time. Now, if we would read section para 5 of UN Model Convention, this also again starts with the non-obstante clause, notwithstanding the provisions of paragraph 1 and 2, but subject to the provisions of paragraph 7. So paragraph 7 corresponds to paragraph 6 of OECD model, which is the independent status. Where a person is acting in the contracting state on behalf of an enterprise, that enterprise shall be deemed to have a permanent establishment in that state in respect of any activities which that person undertakes for the enterprise, if such a person. Now see, there in the OECD model, it was only has and habitually exercises the authority to conclude contracts, and it stopped there. There was nothing more. Here we have habitually concludes contract or habitually plays a principal role leading to the conclusion of contracts. So what was the precaution which the companies were taking earlier was that they would say that we are just doing, communication. We are acting as a communication channel. We are just going and explaining the terms and of the contract. We are just explaining the features of the goods which are being sold. Now, UN model caters to this thing that you are not finally signing on the contract on behalf of the foreign enterprise, but you are playing a principal role which is leading to the conclusion of the contract. Even those cases are covered as per the UN Model Convention. But if you would see, most of the Indian treaties, almost none of the Indian treaties has this particular clause which says that habitually plays the principal role prior to BEP section plan 7, which is the multilateral instrument. So multilateral instrument has changed a few things, which we will discuss later on. Sorry, just give me a moment. I'm sorry. So in UN model, yeah, all okay. It was just. So in the UN model, the definition is little extended. It says habitually plays the principal role leading to the conclusion of the contracts, and the conclusion of the contracts has to be in the name of the foreign enterprise, or please see, it is or, it is not and, or for the transfer of ownership of, or for granting of right to use property owned by that enterprise or that the enterprise has the right to use. Now this term can be used to see to cover tangible goods as well as intangible materials. Say for example, foreign enterprise is dealing in digital goods, digital services, and the Indian agent is procuring or concluding contracts for the digital services for the foreign enterprise. Even right to use is covered, even transfer of ownership is covered. So these things are covered. Or for the provision of services, it is simple. For the provision of services also it is covered, unless the activities of such persons are limited to those mentioned in paragraph 4, again the exclusions, which we will be discussing later on, if exercised through a fixed place of business, would not make this fixed place of business a PE. So exclusions are, let's keep it for the later point of time, we'll come to that. Then the clause B says the person does not habitually conclude contracts nor plays principal role leading to the conclusion of such contracts, but habitually maintains stock of goods and merchandise from which that person regularly delivers goods or merchandise on the behalf of the enterprise. So you see that it is not just playing a principal role, but even if you are maintaining the stock of goods in the source state, even then there can be a possibility, according to the UN Model Convention, that the foreign enterprise can have a place of can have a agency P in India. Now, if you would see in the exclusions, there are certain differences between the OECD Model Convention and the UN Model Convention, and keep in mind that OECD Model Convention generally favors the developed countries, whereas UN Model Convention always favors the source state, which are the developing countries. Now India US DTA also is a very interesting DTA. It is little more elaborate also. In this, the first clause is same, habitually exercises in the first state an authority to conclude contracts. And the B clause is such authority has no such authority, but habitually maintains in the first mentioned state a stock of goods or merchandise from which he regularly delivers. Then the third thing is he habitually secures orders in the first mentioned state. Now, secure orders is much wider than concluding contracts. Securing orders says that even if you are convincing the client to become a customer of the foreign enterprise of which you are an agent, even then, even though you are not concluding the contracts, even you are not finalizing the terms of the contract, just by going there and convincing them, negotiating with them to agree to become a customer of the foreign company, to grant an order to the foreign company, even in that case an agency P can be created. So therefore we must be careful that whichever treaty we are reading, and generally what I have seen, India's treaty has all these three clauses. So securing order is generally found in all the treaties, barring a few, and you must be very careful whether we should be drafting the contracts in what kind of a way, and what are the precautions we should take for mitigating the agency P risk. And this is a very predominant and widespread allegation of agency P, which you will see in cases of Indian company acting as a marketing agent, or even though you are doing some collation of marketing information, even then the income tax officers will allege that there is an agency P. So therefore we must be very careful in reading the text of the treaty, what all kinds of activities are covered in the agency P. Now also one more thing to be very carefully seen is that even if there is a dependent agent acting on behalf of the foreign company in India, but that dependent agent is not doing any of these three activities, even then there is no agency P. So there has to be combination of dependent agent plus any of these three activities, only then the agency P will come into picture. So there have been some case laws where there was a dependent agent. Say for example, you are doing some back office services, you are just processing some information for them, you are doing some data crunches. Even though you are an agent, you are doing certain things on the behalf of the foreign enterprise, but you are not doing any of these three activities, so there will be no agency P. Now, one more thing is that we discussed what is economically dependent. So economically dependent generally is mentioned as once the agent is doing the business activities wholly or almost wholly for one non-resident enterprise. Generally, it was mentioned as the enterprise. So the enterprise is interpreted to mean one enterprise, one foreign enterprise. So what does it mean? OECD says that what is relevant is that agents' activities are for a single principal and not that of the principal, not that the principal's activities are carried on by a sole agent. So see the difference between the two. A foreign company has appointed a sole agent in India, but that sole agent also works for multiple other clients, he acts as a sole agent for multiple unrelated entities. So foreign and exclusivity has to be seen from the point of view of the principal, means there should be only one principal rather than having only one agent. So the very important point is that if the agent is earning its income from only one enterprise, then he will be considered to be economically dependent. Now the next point is an agent acting wholly or almost wholly on behalf of single entity or its group entity indicates a certain degree of dependence such as such an entity may play a significant role in business of that agent, right? Now OECD model commentary states that a person is independent only if he is so legally and economically and acts in ordinary course of business. That this is we have already discussed. Legal independence indicates that agent should not be under any legal obligation to render services to the principal, means he should not be legally bound. What happens many times is, say for example, the Indian company has been incorporated wherein the articles of association have a clause that this company cannot act for any other client, right? In those particular circumstances you have been legally bound, or you are saying that you have mentioned that if you work for any other client also, but you cannot refuse our orders or you cannot refuse our mandates. So those kind of things we need to see whether there is any kind of legal dependence between the agent in India and the foreign principal. So that is also very important to see. And generally what happens is that even if there is any one kind of dependence, either economic dependence or legal dependence, the agent will be considered to be a dependent agent. Then the next point is OECD says that where the person's commercial activities for the enterprise is subject to detailed instruction or comprehensive control by it, such person cannot be regarded as independent. Say for example, I said that in the legal contracts or in the articles of association, you have mentioned that the directors will be responsible towards the parent company, the shareholder will exercise all the control over the business activities of the agent, then you cannot say that the Indian agent is independent is of independent status. And the next point is the fact that principal is relying on special skill and knowledge of the agent is an indication of independence. Now what happens is that in the decision making process, agent uses his own skills and is not generally bound by the instructions of the parent entity, and they have certain unique skills. That is also somewhere sometimes considered by the courts to indicate that the agent is of independent nature and should not be considered as dependent agent. So basically there are various parameters wherein you will need to adjudge whether an agent in India or any source state is considered to be an independent agent or not, and this is very fact specific. So you'll have to consider all the facts together to determine the independent status. So now this is a flow chart. Hanji Piyush.
We have one question by E. Raja Gopalan. Can we take up?
Yes.
A foreign entity in USA has an arrangement with a sole proprietorship in India for supply of their high-end instruments to pharma industries in India. The role of the Indian firm is to secure order and get paid for the agency commission. The Indian agency is involved in installation and technical support. The instrument is imported directly in the name of buyer only. Please clarify if the agency proprietorship is to be construed as an PE.
I'm just reading it again. Just allow me 1 minute.
Okay.
Okay. So I think we need to get some more facts around this. Whether this independent agent, whether this the proprietorship is only solely acting for the foreign US enterprise, or it has other clients also. If
Good evening, sir. This is Raj Gopalan.
yeah,
Yeah.
Rajagopal.
Yeah, this sole proprietorship is not the sole dealing with that particular entity. They are involved with other principals also in various countries. So this is one
Okay.
particular principle on behalf of they are doing this work.
So you have yourself answered that. Would you consider this to be dependent on this US entity?
To an extent.
How?
See, the arrangement between them is the principal and agent.
No. How does it become a dependent agent? Whether the
Because
say, for example, if US company stops giving work to this proprietorship firm, whether his business will stop?
To a great extent, because the main 90% of the income is generated through that particular principle in USA.
Okay, so you are saying that almost wholly, even though there may be some other principle, but that business is not significant, right?
Yeah, they are only, I mean, you can say very meager 5 to 10% maximum.
Right. In that particular, in those circumstances, this person will constitute an agency P.
Okay. Because I mean, for the compliance part of it, I just wanted your clarification.
Yeah. It will be. And there have been some case laws which have put a threshold of 90%. Say, for example, if the 90% of business is being generated from only one foreign principal, then the courts have held that we will consider the agent to be a dependent agent.
Okay. So, thank you, sir. Thank you.
Most welcome. So let's, if anybody has any other query, I will be happy to answer.
Anshul ji, Anand here.
Yes, Anand ji.
Anshul ji, just a small thing that what are the questions we are supposed to ask if we have to consider a person as an agent PE? There would be like 3, 4, 5, set of questions which will determine that after answering these questions, we can finalize that this happens to be a agent PE or not.
So this slide exactly answers your question.
Okay. So
these are the questions you need to answer. You need to ask.
Okay.
Right. First is person is acting on behalf of an enterprise.
Yeah.
If you say that no, the person is not acting on behalf of, they are just independent, they are just acting in normal course of business, then you would say that no P. Means, say, how you would see that a person is acting on behalf of an enterprise. How the customers see the agent, whether they see the agent as a virtual extension of the foreign enterprise. They see the word coming from the mouth of agent as a word coming from the mouth of the foreign principal. Then probably you can say that yes, the agent is acting on behalf of the foreign enterprise. And if the agent is acting such, then you will see whether the agent has an authority to conclude contracts, or he habitually and first is he has the authority to conclude contracts, and then second is whether the agent is habitually concluding the contracts, habitually exercising that authority to conclude contracts in India. That will be the next trigger point. Or there are other conditions which you will see, which we just discussed, that whether the person is maintaining stocks or for delivery, regular delivery, or there is a agent who is securing orders, right? And in some treaties you will find after MLI that there is a clause which has been added that the agent habitually plays a significant role in leading to the conclusion of the contract. So these are the questions you will ask, and if it's still yes, then you will see that whether this agent is economically and legally dependent or not. So as I mentioned that in the case of this proprietorship firm, if the business from US would have say been 60%, and he would have been serving 30-40% of other clients also and generating 30-40% of revenue from other clients, then probably you could not have said that the agent is economically dependent on the US entity. And then you will, if the answer is yes, you will see that whether this person is acting in ordinary course of business or not. And if all the answers are yes, you will be going to no P. So this is how you will, this is a flow chart which you can use invariably to determine whether there is a agency P created in India or not. I hope this answers your question.
Sir, one small clarification I want.
Yes, Rajat.
You are talking about the habitually to conclude the contracts. Does it mean that the authority is vested with the agent to conclude, or it is by default, or what exactly it means by habitual?
Habitual means repeatedly.
So that means by default, or it is, I mean, he exercises as per his,
No, that is dependent on the facts. Means you will ascertain whether the agent is repeatedly concluding certain contracts or not. Whether it is just one-off contract in a year or 2 year that one contract is finalized, or whether that person is habitually going to the market and concluding the contracts. Now, habitually may differ. Say, for example, if there are small goods, there are small ticket items for which you can conclude contracts on a daily basis or a monthly basis. But say, for example, there may be certain big projects for the Indian agent to conclude, and you might say that the big projects come only once in a while, once in a year. So the duration can be varied. You cannot say that habitually means it has to be repeated every 1 day or every month or every year. It has to be seen according to the nature of the foreign enterprise. Say, for example, if a foreign company is in the business of establishing nuclear reactors. So now nuclear reactor in India is not set up every day and not a contract is granted every day. But if the Indian agent, Indian company is acting habitually to negotiate the dealings differently with Department of Atomic Energy, and for different kind of contracts they are negotiating, even though the authority is not been executed because there is no contract which has been granted. So therefore, all the facts needs to be seen. What kind of business the foreign enterprise is into, that needs to be seen, and then you will be able to arrive at whether the authority to conclude has been exercised habitually or not.
Okay. So good. Thank you. Thanks.
Right? Should we move on?
Yes, Anshul.
So this is a summary of what is the OECD model convention, UN model convention, and what is the business connection. As I mentioned that there has been a change in the definition of business connection in section 9 also. So you would see that the in OECD model there is only one thing, habitually concludes contract. In UN model it also says that habitually plays the principal role leading to the conclusion of contract. And then there is a second clause which says that has no such authority but habitually maintains a stock from which delivery is made. Then in income tax, there is also the concept of securing orders, which you will find generally is there in the Indian treaties. Most of the treaties you will find this clause as well. Now, these are some rulings on agency P. Varian India Private Limited is a very simple ruling which says that the Indian company was acting on behalf of multiple companies of the group, of the Varian group. So the court held that once you are acting on our behalf of multiple entities, there is no single principle which we can pinpoint that this is your main principle. Then we will say that you do not constitute a agency P in India. Now, this is something which had been followed very vociferously in past, and all the legal consultants, all the tax advocates would argue on this point of time, and they will also constitute the arrangements in such a way that multiple enterprises of the foreign group entity will enter into contracts and will give revenue to the Indian agent. Say, for example, if item A is supplied by company A, item B is supplied by company B, item C is supplied by company C, but all these items are linked to some extent, and all these three group companies belong to one multinational group only. So this way they could mitigate the risk of the agency P. But what happened in GE Energy Parts, which is the last case which is mentioned on this slide, in GE Energy Parts, Delhi ITAD and then Delhi High Court also ruled that if the contracts are only for one group, even though there are multiple entities within the group, the Indian company or the Indian liaison office, here the entity was a liaison office. The liaison office was one of one entity, but this liaison office was providing services to different entities of the group. In that case, it was held that even though the activities are being directed towards various entities, towards multiple entities, but because the entities belong to one group only, and the liaison office is actively engaged in securing orders or going to the customers and concluding contracts, therefore a permanent establishment in the form of agency P will be held to be present in India. So you can see that there have been, changes in the, so this case is of 2019 G Energy parts, and variant was of 2013. So you can see that judicial prudence is also evolving over a period of time. Now in Nokia Networks, this was a simple case of foreign company supplying the products and Indian company installing and providing some maintenance and services to the Indian customers. So Nokia Networks, as we know, are also into telecom equipment, big telecom equipment, wherein the parts are supplied to telecom operators, and goods are supplied directly from the foreign company, whereas certain installation and commissioning services are being rendered by the Indian entity, Indian subsidiary company. Now, in this particular case, what was held is that even if someone can say that the Indian entity is dependent on the foreign entity, but none of the three activities which were listed in the agency P clause were being performed by the Indian entity. They were neither securing orders, they were neither concluding contracts, they were neither maintaining stocks on the behalf of the foreign entity. They were just providing certain installation and commissioning services, which was not covered as one of the listed activities, and therefore it was held that there is no P. And this case has also been approved or upheld by the Delhi High Court. Then there is one other interesting case, Daikin Industries. Daikin Industries, very common name. Daikin, you would have known that Daikin is a air conditioning solution provider, and it is a Japanese company, big Japanese company. So one product which we see is the home ACs, which is particular unit which is sold in the market, and generally that is sold by the Indian company. But there are big air conditioning solutions provided to big companies wherein the entire building has to be air conditioned, and it is not possible to be provided by through one single unit, but an entire air conditioning solution has to be provided. For the technology and for the equipment to provide these air conditioning solutions, the Japanese company was directly concluding contracts with the Indian entity, with the Indian customers. Now the income tax authorities alleged that for making some sales in India, the Indian company maintains such a big sales force, and while concluding the contracts of such big nature, in fact, which were exceeding in the terms of turnover, which was clocked by the Indian entity, the turnover of the foreign entity was much more than the Indian entity's turnover. The income tax authorities alleged that without the involvement of the sales team of Indian entity, the foreign company would not have been able to sell its products or its solutions in the Indian market, and therefore, by virtue of circumstantial evidence, it should be held that the Indian company is habitually concluding contracts or securing orders on behalf of the foreign entity, and the ITAT upheld this argument of the income tax authorities, and they said that it is but obvious that for executing such a big nature of sales in India, you would definitely be using the services of Daikin India, and the Daikin India, the councils of the Daikin India were not able to prove on facts that how come the foreign entity was interacting with the Indian customers directly. They were neither able to produce any mail exchanges, they were neither able to provide any kind of substantive or evidence which could prove that the foreign entity was directly dealing with the customers to secure orders. So in absence of that, supportive evidence, the tribunal as well as the Karnataka High Court held that the Indian entity will be considered to be an agency P of the foreign entity. So these are few cases. Now there is one more concept which we are not discussing here today. It is about the attribution of P, profits to the P. Now what happens is that
Anshul, I have a small
Yeah, Rinkesh. Yes, Rinkesh, tell me. Rinkesh, your voice is not clear.
When you set out activities, many group companies
Rinkesh, 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 can you write your question in chat box? Because audible is not clear. Anshul,
Rinkesh, we could not hear you at all.
I think there is network problem.
Yeah. There are other queries also which are coming in the chat box. So let's take that one. Piyush, you can also write to Rinkesh in the chat box if he can type
Yeah,
the question.
I'm writing it.
So I'll take first question. Nayaz has asked, Anshulji, can you please share your thoughts on single brand retailing of foreign enterprise for the foreign enterprise? So Nayazji, foreign enterprise, if we are retailing in India, most likely I would be acting as a principal to principal buyer of the goods, and only then I can sell it in the Indian market. If I am into retail business, I'll open I cannot hold the stock on behalf of the foreign entity. That is not allowed as per the FEMA regulations, or to my mind, any other regulation. As an agent, I will not be acting as an agent in retail business. I'll be acting as a stockist in my own name. As a seller, means I will be purchasing the goods first and then sell it out to the customers in India. So in that particular circumstances, there will be no question of agency P, because there is a sale happening to me. So agency P can only be created when I'm only acting as an agent to conclude contracts. So in retail business, to my mind, this situation will not arise. iPad has asked, has acting in ordinary course of business been defined? No, it has not been defined in the treaty. So we'll have to see it in general terms and according to the facts of each case. Then ANJ has asked, an overseas film company entered into contract with an Indian entity to carrying out film shooting activities, and the Indian entity was instructed to do the shooting and hand over the negative of the film to overseas entity. Except for this one film, the Indian entity did not handle any project. In that year, the Indian entity had to work with a specified budget. Will this be construed as dependent agent? Sir, I would ask you a question in the form of an answer, whether this production of a film, shooting of a film, will be one of the activities which we had listed. Whether it can be said to be concluding of contracts on behalf of foreign company, conclusion of contracts with customers. No. Then there is no securing of order, then there is no stocking of merchandise. So even if you can say that the Indian film company was dependent economically on the foreign company, even then there was no execution of any one of the items listed in the agency P clause. Therefore, there will be no agency P.
Thank you. Yeah.
Okay, Alok has asked, going by definition of every subsidiary could run the risk of being considered as PE of foreign principal. What is the key recommendation to avoid such a conclusion? Sir, the risk mitigation is, as I mentioned, that you can enter into contracts where you will not be giving any kind of authority to the Indian entity to conclude contracts. Further, you also need to see that what kind of activities are being activities are being carried on by the Indian entity. And one of the foremost safeguard is to first is to make the Indian entity a trader rather than an agent. So the Indian company, if purchases the goods in its own name and then sells it into the Indian market, then the agency relationship is itself extinguished, and therefore there will be no risk of agency P. So more and more companies nowadays are converting into a trader rather than being just an agent. So that is one of the prime strategies being followed these days. Then Nitin Goyal, generally Indian subsidiary neither engaged in trading, works in marketing agent not included. I think this is an answer. Rinkesh, was the Indian entity considered P for every group company for whom that entity for conducting business for in GE case? Yes. Yes, Rinkesh, it was held to be a P for all the entities which it was acting for. Right, and all the
Thanks.
profit attribution was profit attribution is something which was not commented or deliberated. That will be a second phase of litigation because generally the attribution goes back to the AO. So that we will have to see. But there are very interesting facts related to the GE energy parts. I'll just briefly mention a few things. That first of all, when the assessment was being made, the assessing officer went to the LinkedIn website, and from LinkedIn website he, took out all the profiles of the leading professionals or the leading personnels employed by the license office, and they just mentioned it before the courts also that this is the LinkedIn profile, and they are mentioning such big things in their LinkedIn profile that they are doing such things, they are doing business development, they are acting on behalf of the parent company, their targets were so much, they have achieved so much. So all these things were mentioned there, but the GE Energy parts counter argued that LinkedIn profiles are always high profile, means they cannot be relied as true evidence in the court of law. So one should not be relying upon LinkedIn profile merely to bring to a foreign entity taxation in India. So the income tax officers then thought beyond LinkedIn profiles, and what they did was they asked the liaison office to submit all the employee appraisal forms of all the employees of the liaison offices. And when the appraisal forms were submitted, the appraisal forms also had the similar kind of things, that they were provided targets. The performance was based on achievement of those targets. It was specifically mentioned that you have to conclude sales, even though the agreement between the liaison office and the parent entities were not similarly drafted, but the performance appraisal forms of all the employees were then put on record as a legal evidence, which was relied upon the tribunal also, which was appreciated as a factual evidence, and it was decided that you cannot you cannot deny the fact that the Indian liaison office was acting on behalf of the foreign companies and concluding contracts in India. So one has to be very careful that to what extent the income tax officers can go, to dig out the evidences. So be careful now. What we have started advising our clients is that be careful about your appraisal forms also, what the kind of targets you are setting up. And nowadays, all these things are there in the systems. So you cannot even delete it going forward. So therefore, one should be keeping in mind all those things while dealing with such cases. Now, there are some changes which have been brought in by the multilateral instrument, and multilateral instrument we'll be dealing it in the last session, but I am just touching it upon in brief because we are discussing agency P, and agency P is one of the very heated discussions which have been a very prominent discussion which have been there in article in web section 7. What the changes which have been proposed and which have been now enacted, whatever certain countries have accepted these changes vis-a-vis India for the covered tax agreements. There are certain countries where these changes have already been implemented from 1st of April 2020. Say for example, one country is Japan. So Japan has accepted the proposal of changes to Article 5 and agency P clause. What does this clause read? Where a person is acting in a contracting state on behalf of an enterprise, and in doing so habitually conclude contracts or habitually plays the principal role leading to the conclusion of contracts that are routinely concluded without material modification by the enterprise. Means there are 2-3 limbs to it. Habitually plays the principal role leading to the conclusion of contracts that are routinely concluded. Means once I as an agent in India have concluded the finalized the terms of the contract, it is more than routinely happens that the foreign enterprise will not do any kind of changes to the terms and conditions, and they will accept it as it is most of the times. Obviously there can be certain modification which are minor or here and there, or if there are 100 contracts which have been concluded and the foreign enterprise have suggested changes only in 5 to 10 cases, then also you can say that the foreign enterprise is routinely accepting the contracts without material modification. So in those circumstances, now there can be held to be a P in India, right? Now, what are those contracts? The contract can be in the name of the enterprise, the foreign enterprise. It can be for the transfer of ownership of or for the granting of right to use, which we discussed. So you would see that the conditions or the the parameters which were already existing in the UN model have now been accepted in the OECD model also, and through multilateral instrument many of the treaties now stand changed. So what I would suggest is, whenever you are deciding upon the facts of a particular circumstance or a particular case, you should see on the income tax website, wherever the changes have been made through multilateral instrument, there is another treaty which we call by the name of synthesized text. In this synthesized text, you will find the treaty in the amended form after the implementation of MLI. So you can go and check the synthesized text as to whether this particular clause has been changed in this particular treaty or not.
So
Then
can a transfer of technology come under that?
So transfer of technology from the parent company to the customer in India, where the agent is playing a principal role in conclusion of that contract.
Yes, I mean precisely that is the case.
Yeah, those kind of cases will be covered if the treaty which you are seeing, say for example, if you are seeing India-China treaty, China is not covered, India is a under the multilateral instrument. So that treaty will not change.
Okay.
Right. So you will need to see, and as per the multilateral instrument, which all of the treaties of India has changed, and also within those changed treaties, which all countries have accepted this definition to be, inserted in agency P clause.
Okay.
So that is what you will need to see,
So
treaty by treaty.
Okay, that should figure in the agreement, no? That's what you're saying.
Yes, it should be there in the synthesized text.
Okay, thanks.
Right. Then there is another definition, which is there is a change in the dependent agent. As we just discussed, that there were cases in the past wherein if an entity in India was acting on behalf of multiple enterprise, although they were belonging to the same group, the taxpayer was arguing that we are not economically dependent on one enterprise. To counter that argument, the treaty has now been amended only on those treaties which have been accepted, wherein this paragraph has been amended, where however a person acts exclusively or almost exclusively on behalf of one or more enterprises to which it is closely related, right? So one is thing that one or more enterprises, and the other connected thing is closely related. So now what is closely related? Closely related was not defined in the treaty, so they have defined closely related also in the amended definition. What they mean, generally what it means is that you must be controlling at least more than 50% of the stake in the enterprises. So the multiple enterprises, more than 50% of those enterprises should be controlled by single parent, either directly or indirectly. So in those particular circumstances, you have to see whether the foreign enterprises, multiple enterprises, can be considered to be closely related, and if they are closely related and the Indian agent is working for all those multiple enterprises as well, even in that circumstances, you can consider the Indian agent to be a PE, agency PE, and the agency PE of all those multiple enterprises, right? I think we are done with this agency PE. Any questions as of now? I'll be happy to answer.
Anshul,
There was a question in the chat box, sir.
Okay. Just
Anshul?
मैंने अपना वीडियो जानबूझ के बंद किया है. Just give me a moment. So
Okay.
just give me a half a minute. I'll be back.
Okay.
Just give me half a minute. Yes.
So I have sent a question on the chat box.
Right. I'm just reading it out. A German company has been awarded a contract for supply of wash plant to government. Wash plant means
that's for the train sets. Wash plant for the train set.
okay. Subsequently, the contract was amended to have a local representative liaison with the SPB for installation and support. The euro payment was paid in equivalent Indian rupees to local representative as per the authorization of German company. Please clarify, sir. Please guide me. Means whether this company is economically dependent.
No, they are the sole representative for that particular German company.
Sir, I mentioned that sole representative has to be seen from the local representative point. Means whether the local representative is only and only acting for the German company and it does not have any other client of its own.
They have multiple clients, but this particular thing was later amended to the original contract. Originally, the supply was to come from Germany, and it was a single company which was to do all the supply, installation, etc. But subsequently, the local representative was brought into the contract, and they are independent agency which are managing many projects.
Many projects. So you are saying that it is not economically or legally dependent on German company.
To an extent, because again, there's local support of installation, testing, commissioning, and after sales supports to be given by the local company.
No, that is fine. But would you say that the local representative is dependent on the German company for entire of its business, for wholly or almost wholly of its business?
These are all niche things,
Sir, these things do not matter whether these are niche or not niche.
Okay.
Local representative can be acting as an agent of multiple clients for this niche services.
Yes.
L&T, say for example, L&T is into a very niche kind of business, high-end engineering services.
Yeah.
Right. So they can support and they can work for multiple clients.
Okay.
So would you say that L&T will become dependent on all of these clients? No. Say for example, even if you would say that this company become is economically dependent, they are only acting on and for one German company only. Even then, would you say that this installation and commissioning part of activities, business activity, is one of those listed activities? Is the local representative habitually exercising an authority to conclude contracts?
No, he has no authority.
I would say no.
He has no authority.
Is he maintaining stocks on behalf of the foreign enterprise? I would say no.
No.
Is he securing new orders for German company? I would say no. So even if you would say that the local representative is a dependent agent, even then, if the activities are not one of the three listed activities, there will be no P.
Okay. Thank you.
Anshul?
Yes, Piyush.
Krishna was asking, is there any Supreme Court rulings with reference on agency PE?
Supreme Court ruling, I don't think Supreme Court, but there are a lot of rulings in the case of Set Satellite and as I mentioned, Daikin. There are High Court rulings, a lot of High Court rulings. But I don't recall as of now about the Supreme Court ruling.
Can you share any link where they can find rulings on PE or international taxations?
Sir, that for you can either use Google, agency P case laws. Google is the best way, or you just take a subscription of Taxman. Taxman is we generally use Taxman to find out case laws. There are a lot of cases on agency P, but all have been decided at the level of High Court. We have not seen too many cases of Supreme Court. I can't recall as of now.
Thank you. So can we move?
Right.
One.
So let's come on to the exclusions of the P. What are the exclusions? So Article 5 para 4 of OECD Model Convention provides for what are the exclusions. So the exclusions are, first, even if there is a place of business in India where you are carrying on business, where there is a permanency test also, satisfied, where the duration test is also satisfied, even then in certain circumstances, if certain kind of activities are being followed, there may be a case that the place of business in India is not considered as a permanent establishment. Now, what are those circumstances? I'm not going into the Indian treaty, but we'll just consider the general terms. It is storage, display, or delivery of goods of merchandise belonging to the enterprise. Say, for example, in India, a physical warehouse is being maintained where merchandise is stored, displayed, or there is a delivery, regular delivery, which is happening out of this warehouse to the customers. Then it should not be considered as a permanent establishment. The second point is there is a maintenance of stock only for storage, display, or for the purpose of storage, display, or delivery. Let me explain you the difference between the first and the second. But generally, people confuse that it is the same thing.
The
But
second one is processing for by another enterprise.
no, that is the third one. I am talking about A and B.
Okay.
Now, A and B means A is that the use of facility. The facility is maintained by a third party. Right? Say, for example, there is a warehouse being maintained by a third party. You do not have it on lease. It is a third party's warehouse, but you are using the facility for stocking of the goods. Then the second point is that I have leased out a premises on my own, and then I am using that premises to maintain the stock of the goods. So this is the fine difference between the A and B, right? The third is that goods come into India. You would also see that in GST there are provisions that customs duty will not apply or GST will not apply if the goods have been imported into India for re-export. Right. So in these kind of re-export kind of things, there is some processing happening on the goods and they will go back to. So in sense, they say that there is no business activity happening in India. It is just certain processing of the goods or some value addition is being made and they'll go back to the foreign enterprise. So there should not be any PE. Now, the fourth one is purchasing the goods or merchandise or of collection of information. So if you have created a project of created a liaison office, there is a case of Nike that Nike was using its liaison office just to procure goods from India. So they were using India as a source hub for their global product range. So they had appointed certain contract manufacturers and the liaison office was just interacting with the contract manufacturers for the successful export of goods. They were just maintaining a check on the quality or the delivery process. And there is a case of, I think, Karnataka High Court, which said that Nike, by having this liaison office, should not be considered to have a PE in India. Now we'll come to that case once more. There is another case of similar nature. Then the E point is maintenance of a fixed place of business solely for the purposes of carrying on or for the enterprise any other activity of a preparatory or auxiliary nature. Now this is a generic term. This says that apart from the above specifically mentioned activities, you are doing certain activities which are not very core of your business, but which are auxiliary or preparatory in nature. Say, for example, in one of the cases, there was a bank based in Dubai which has set up a liaison office in India, and the job of liaison office was just to process the checks. Now, it was argued by the income tax department that processing of check is very core process of a business, of a banking business. So therefore, even the processing of checks by the Indian liaison office should be considered to be core business activity, and therefore liaison office should be deemed to be a permanent establishment. But the courts held that processing of check itself is not a core business. Just ticking the check and checking whether all the particulars on the check are correct or not, and just forwarding them. This does not mean core business of banking. Banking is more of a risk taking, more of lending and collecting deposits, and therefore just merely processing of checks is not a core business activity. Therefore, that was covered under the E clause wherein any other activity of preparatory or auxiliary in nature. So that is where you have to see in the terms of entire business of the company, whether this particular activity which is being carried out in India or in the source state should be considered as preparatory or auxiliary in nature or not. Then the last point is that even if there are activities which are in combination of any of the above activities, even those combination will not be considered to be creating a permanent establishment. Now, why does Article 5.4 is required? As we said that preparatory and auxiliary, they are very minuscule kind of activities which are being undertaken through a place of business in India. In those circumstances, it was agreed or it was decided that will not tax these activities because it is very difficult to attribute profit to these kind of activities. So therefore, it has been agreed both in OECD model convention as well as in UN model convention that will not tax certain kind of activities. But you would see that OECD model is more elaborate and they have covered a lot more, a few more activities as compared to the UN model convention. What we have seen read above is OECD model covers two extra items, which is one, the last bullets, if you would see, use of facilities for delivery of goods. Now, UN model and the developing countries generally do not agree to delivery of goods being considered as minuscule activity. They generally argue that if you are maintaining a warehouse or a place of business through which you are regularly delivering goods to the Indian customers, it should not be considered as minuscule activity or preparatory or auxiliary in nature. Say for example, take an example of eBay US. eBay US is in the business of selling goods only. They are just procuring goods and selling goods. And they maintain a warehouse in India for regular delivery. Means say for example, if I sitting in India was to place an order on eBay US website, and on my placing the order on eBay US website, the goods are delivered to me from the Indian warehouse of the eBay. Now, what would you say? Whether this is a minuscule activity or this is the main activity, because time is of the essence in these particular circumstances. So therefore, this particular kind of activity may not be regarded as preparatory and auxiliary. This is both related to the delivery of goods. One is either you are using third-party warehouse or you're maintaining on your own that warehouse for delivery of goods. OECD model tends to cover it, saying that this is preparatory and auxiliary, whereas UN model says that it is not preparatory and auxiliary. They have not covered it. Now, for Indian treaties, you will have to carefully look for both these items. In some of the Indian treaties, you will find delivery also. But how that wording has been mentioned, how that particular clause has been drafted, you'll need to see carefully for each and every particular treaty, and then only decide whether this is preparatory and auxiliary or this is covered in the exclusions of PE or not. Now, what is the meaning of preparatory and
Anshul?
auxiliary? Yes.
Rinkesh is asking that you told that delivery of goods from stock maintained by agent would lead to agency PE. Now the same is listed in para 4 as would not amount PE. Isn't this contradictory?
Sir, this is contradictory because we are reading different articles. We are reading different model conventions. So if you would see, maintenance of stock is not there covered as an activity in the OECD model convention, right? So let me go back.
So in my opinion, I'm asking which would we follow? I mean, while
So
applying
we'll not follow. See,
criteria,
there is no generic term. We'll have to see each and every treaty. Each and every treaty of India, yeah, each and every treaty of India might have different language. So let me just explain you in the OECD model convention. In OECD model convention, maintaining of stock is not there.
Okay.
And therefore they have provided it in exclusion. Whereas UN model has this and therefore they have not provided this in exclusion. I hope, Rinkesh, I am able to clarify.
Got it, Anshul. Thanks, yeah. Thanks.
Most welcome. So therefore, that is what I'm saying, that there are different model conventions and they have taken the activities in different nature. So where the OECD model considers delivery of goods to be preparatory and auxiliary in nature, and therefore they have not covered it in the agency P, while they have covered it in the exclusions. Similarly, means contrary to that, UN model has considered the maintenance of stock to be creating an agency P, and therefore they have not included it in the exclusions of the P. So while this is the model convention, this give you a broad understanding as to how to read the treaty. But obviously there are more than 90 or 100 treaties which India have executed. You'll have to read whatever treaty you are dealing with at that point of time to consider whether there is a PE or not. Now coming on to the general meaning of preparatory and auxiliary has not been defined in the treaties. So we'll have to go by the dictionary meaning on the general meaning. Preparatory means that something prepares or serves to prepare for something following preliminary or introductory. Auxiliary means which is helping or assisting or supporting, which is kind of a fringe activity. You can say that it is a fringe activity, not a core activity which can be said to be contributing predominantly to the profits of the entity which are being generated through those business activities. So as I mentioned, that each fact has to be considered on a standalone basis whenever you are dealing with it. Now this is one case study. There is a foreign company which has a liaison office in India. A liaison office acts as a sales and marketing agent kind of a thing, means not particularly, but that liaison office identifies customers, seek technical specifications, send quotations to the head office, then negotiates also, finalizes the price, carries out after sales and follow up on payments also. But the goods are directly delivered from the foreign company to the customer. So what would you say? What is your take? Whether this liaison office constitutes a permanent establishment in India or not?
I think no.
No. Why?
But all the control is being exercised by the authority sitting there. So they don't have any role in deciding or concluding a contract.
Okay.
So for everything, they have to look back upon the head office, whether it is finalizing a contract or the price, or and the supply happens directly from the head office to the customer directly. So considering all these activities put together and the authority vested with the head office, I think it looks like it seems to be not a P.
Anybody else?
It seems to be a P.
Seems to be P. Now, what are your
arguments? It seems to be a P.
What are your arguments in favor of the
They
tax
are
department?
negotiating, finalizing prices.
Right.
They are negotiating, finalizing the prices with the buyers in India. So they are playing a principal role in concluding contracts.
Okay. Any other point which can
Hello.
come across? Yeah.
Yeah, Kavindra.
Yeah. Hi, Anshul. The only fact is they are also following up with payments.
Okay.
So that also gives us a strong thing, no? That it's a P.
Okay.
I'm not repeating what the other members have said.
So
but
is
this,
collection of payment one of the listed items for agency P?
but I'm linking it to these because I'm looking at it from a different angle actually.
Okay. What is that?
See, you get into the collection of payment only, that means the relation with the head office is very deep. Otherwise, receivables and receivables follow will not come into picture. No?
So you can always follow up, means you can always appoint an agent to follow up for the payments, and they are not acting as a collection agent, but they are just following up for the payments.
I'm talking in conclusion with all the activities, but for my strong contending point, which apart from others, is this follow up on payments after sales.
Okay. So let's see what the court held. It was a case of Gibbon Corporation. In this particular case, First, it was decided by Bangalore High Court and then upheld by Karnataka High Court that liaison office of the Korean company was performing functions such as identifying new customers, pursuit and follow-up of customer, price negotiation, etc. That would be treated as a permanent establishment of Korean company as defined under Article 5. Now, one of the very important and basic points to be seen here is that it is a liaison office. It is not a separate legal entity. There is no agency and principal relationship, first of all. Probably that has not been mentioned in the Japan Corporation, but one very prime thing to be seen is that there is no principal agency relationship. It is a virtual extension of the parent company itself on the floor of Indian entity. And the only thing which can be excluded from the definition of branch office, you would have seen Article 5.2. It was listed branch office, place of management, that would be treated as a permanent establishment in Article 5.2 itself. And if you have to move out of Article 5.2, you have to come to the exclusions to see whether these activities are preparatory and auxiliary in nature. So even if I do not look at the agency P function, agency P clause, even then the liaison office will become a PE of the foreign entity. Am I clear?
Yes.
So the point I'm trying to make is that in this particular case, probably the agency P is not at all triggered because the liaison office itself is a virtual extension of the foreign entity. And because these activities are not covered under the exclusions of article provided in Article 5.4, you will treat the liaison office as a P.
இங்க வந்துட்டு இன்னொரு பேங்க் அக்கவுண்டே போட சொல்றாருப்பா. 4 பேங்க் நீ எழுதிருக்கல. பேங்க் அனலிஸ்ட்ல எவ்வளவு பேங்க் இருக்கு?
Sorry, ANJ sir, मैं आपकी language समझ नहीं पा रहा हूँ.
Liaison office and the agency. I think the analysis was made as per the agency, whereas this should be treated as a liaison office, and then the conclusions are based on the establishment of LO.
Yes.
Okay, thank you, sir.
Now, there have been some changes in the BEPS Action Plan 7, which is through the multilateral instrument. Here, a few new additions have been inserted. What was happening is that there were different, as we mentioned, that even the combination of some activities will be considered not to create a PE in India. So the foreign enterprises were misusing many of those things, that they were bifurcating their core business activities into such minuscule activities, and they were housing those different activities in different offices. Say, for example, one liaison office is only processing check, one liaison office is only analyzing the credit worthiness of the deposit seeker or the loan seeker. They were doing the credit analysis. Then there will be another liaison office which will be catering to the follow-ups of the payment. So if you would see each individual activity, probably you would consider it to be preparatory and auxiliary in the nature. But if you would combine those activities, and you would see that, okay, the banking transaction, all the smaller parts of the banking transaction, if clubbed together, the core business is being carried out from the source country. So this was a very big challenge as to the source countries were not able to get their fair share of the tax revenues. Therefore, this anti-fragmentation rule has been inserted in the treaty through the multilateral instrument, wherein it says that wherever the enterprise maintains separate fixed place of businesses for carrying out preparatory and auxiliary services, which are separate organizationally, and this is prior to BEPS, which is either separate organizationally or separate through locations. Even then, in those cases, you will not consider it to be a PE. Now, what is the change? In the changed paragraph 4, they have inserted a few clauses, 2 clauses basically, which says that the place or other place constitute a permanent establishment for the enterprise or the closely related enterprise under the provisions of the article. Means even if you are a PE for one enterprise, and if you are supporting other enterprises also, then you will become a PE of all the enterprises. That is one. The second is that you have created different offices, but a combination of all those activities would lead to a conclusion that the combination is not itself a preparatory and auxiliary in nature, then also you will consider the activities to constitute a P. So the difference of organizational segregation or the locational segregation of the offices in the source state has been done away with, kind of a thing. So therefore we need to see which all treaties have been amended to these clauses, and therefore we'll need to be careful while deciding on a particular set of facts going forward. Now coming to Article 5.7, it's a very small thing. I think we should not spend too much of time. The fact that a company which is a resident of a contracting state controls or is controlled by a company which is a resident of the other contracting state, means subsidiary parent relationship, or which carries on business in that other state, shall not by itself constitute either company a permanent establishment of the other. I mean, just by the mere fact of a parent subsidiary relationship, or just by the mere fact that one company is holding certain shares in the other company, this fact itself cannot be considered to create a permanent establishment of a foreign company into Indian location. Now this is one case, this case study, a very small case study. An Indian company was acting as a R&D hub for a foreign company, and the income tax authorities alleged that the Indian company, because it is the 100% subsidiary of the foreign company and it is acting wholly and exclusively on behalf of the for the foreign entity only, therefore the Indian company should be considered as a permanent establishment. So what is your take? What would you say? That any guesses?
Should not be treated as a P.
Should not be, absolutely correct. Should not be treated as P. There was this case of Adobe Systems Incorporated, and it was exactly held that the Indian company is a separate legal entity. The premises of Indian entity are not at the disposal of the foreign entity. Secondly, means they were not concluding any contracts, they were not securing any contracts on behalf of the parent company, and therefore considering all those tests, it was held that Indian company was not to be considered as a permanent establishment of the Adobe Systems Incorporated, which was a foreign entity. Also, the one important point which I already mentioned is that even if there is a P, even if there is a circumstances wherein you can say that agency P has been established, say for example, but if you can prove that the Indian agent has been remunerated at an arm's length price, then also there will be no further implication on that. And as we discussed yesterday, the case of Galileo, the system, the software on the systems of a travel agent was considered to be constituting a P in India, but when it was determined that the travel agents or the Indian distribution agency had been remunerated at arm's length price, the courts held that there is no further attribution required, and even then, even though the P was held to be existing, there was no further implication to that. So you would find this concept there in decided by Supreme Court in the case of Morgan Stanley, then by Bombay High Court in Set Satellite, and then by many other cases following the Morgan Stanley and Set Satellite. So Set Satellite and Morgan Stanley are the two landmark judgments which are dealing with the arm's length principle when the Indian entity or the Indian agent has been remunerated at arm's length price, there is no further implication. Now coming on to Article 7, this is the Article 7 which says that once a P has been determined, has been held to be there existing in source country, then what? Then Article 7 talks about taxation of business profits. So what is the scope of taxation? There has to be a distinct and separate enterprise approach. We'll cover one by one everything. So the basic framework is there is a enterprise of a foreign company which is a resident of a foreign contract of the other contracting state. Then there is a constitution of P, there is an office, or there is a, by any means, by way of installation P or service P or agency P, you have created a P in the source state. Once a P has been created, then the taxability will happen under Article 7. What does it say? As per OECD model, now this is a very, very simple and straightforward kind of a thing. Profits of an enterprise of a contracting state shall be taxable only in that state, unless, means of an enterprise of a contracting state means the resident of a contracting state. So resident of a contracting state shall be taxable only in the country of residence, unless the enterprise carries on business in the other contracting state, means the source state, through a permanent establishment situated therein. Also, if such enterprise carries on business as aforesaid, the profits that are attributable to the P in accordance with the provisions of paragraph 2 may be taxed in that other state. So matlab, one thing is that you created a P, it can be taxed, the profits can be taxed in the source state, but how much of the profits? Only those profits which were attributable to the activities carried on to that permanent establishment. Only those profits can be taxed in the source state. Now this is a very straightforward, simple paragraph 1 of Article 7. Now let's come on to Article 7 of UN model. Now you would see how long it has become. As they say that they are, always trying to protect the interests of the source state. So what does it mean is, now there are 3 clauses here. One is as is attributable to that permanent establishment, that is the same case which was there in OECD model. Then there is sales in that state, that other state means the source state, of goods or merchandise of the same or similar kind as those sold through that permanent establishment. So what does that mean is that permanent establishment is engaged in, say for example, trade of certain goods, they are selling certain goods, but the foreign parent enterprise, means the foreign enterprise, receives a direct order from a customer in the source state, in which the permanent establishment was not at all involved. There was no linkage, they didn't go to the customer. But for certain other similar kind of products which the permanent establishment is not dealing in, the customer orders directly to the parent enterprise, and the parent enterprise directly supplies all those goods to the customers. Even those kind of transactions will be covered, and the profit attributable to those transactions will also be taxed in the source state, just because you had a P which is also dealing in the same or similar kind of goods or merchandise. Then the C thing goes one way beyond. It says that not just sale or purchase of similar kind of goods, but even if the profits are earned through similar business activities, means business activity is trading. Now permanent establishment is dealing in, say for example, laptops, but the parent company has supplied, say for example, vegetables. They are not similar at all, but because the business activities are similar, they are trading in nature. Therefore someone may say, the income tax authorities may allege that the nature of business is trading. Therefore if you find this particular clause C in any of the treaties, you will have to see that even if there is a direct supply of goods, which we generally say that this is offshore supply of goods is not taxable in India as per the general principles. But if that particular company has a P in India, then we might have to tax the direct offshore supply also. And that is one of the prominent and predominant reasons that even while purchasing goods from a foreign party, we generally ask the clients to take a no P declaration from the foreign enterprise, that you do not have any kind of P in India. Because if they have a P in India, the force of attraction rules may apply, and we might have to deduct tax, withhold tax on the supply of goods also. So that is one thing which is called force of attraction. So now in the UN model treaty, you will find this force of attraction rules. Now force of attraction means that because there is a PE, there is an attraction which will attract the profits which are not effectively connected to the P to be taxed in the source state. So now this is force of attraction, and you will find this force of attraction in some of the treaties. I'll mention some of the examples. Now what kind of force of attraction you will find? There is full force of attraction, that if there is a PE in a contracting state, in a source state, then we don't bother what kind of revenue, whether it is similar or not similar. Any other activity which is directly being undertaken by the parent entity, parent enterprise, on the land of source entity, source state, will tax all of it. So there is no complication. we'll tax everything. Similarly, there is no force of attraction, which is the simple wordings of the OECD model convention, where there is no mention of attribution other than the attribution related to the P. So these two are very simple. There is no doubt. The doubt arises in the limited force of attraction, which says that same or similar kind of goods and merchandise to be sold, or same or similar kind of business activities to be carried on as are being carried on by the permanent establishment. So we'll discuss limited force of attraction in more detail. So first issue is obviously what is same or similar. Same or similar is not defined in the treaty. So how should we go about it? We should, with the general laws of interpretation, you go by the general meaning or go by the dictionary or ordinary meaning of that particular term. Same means resembling in every aspect or identical. Similar means they are not having identical characteristics but having similar uses or similar characteristics of use or parameters of their qualities. So those kind of things will be considered as same or similar. So I have given certain illustrations. Say for example, computer or copying machines. Now copying machine is a scanner. They do not process data, but computer is something where you input data and you get some different output, value-added output. So these two are basically different equipments. They have different characteristics of their goods. So one may say that they are not similar or same in nature. Now when the treaty you are reading only has clause B, which says that sale of goods or merchandise of same or similar nature, in those circumstances probably this distinction can work. But which treaties also have C clause wherein the similar kind of business activities are also covered, then probably you might not be looking at the differentiation of nature of the goods, but you will say whether we are selling the computers into the territory through permanent establishment and we are selling copying machines directly to the customers through parent entity. The activities of trading is of sale of goods. So therefore probably in those circumstances even the goods not being similar can be covered under the force of attraction rule. So similarly, copying machines and scanners are obviously similar kind of things. Desktops and laptops. Desktops is a stationary system, but laptop is a mobile kind of a thing. You can carry it along with you, but the work done by both the systems are same. So therefore, they can be considered to be similar. So what are the principle laid out? So nature of the goods, characteristics of the goods, purpose or utility of the goods. These are some basic things you can ask while you are deciding whether these are similar or not. Then the similar activities, whether the same or similar activities have not been defined. Supreme Court has analyzed and put down certain parameters, which is saying proximity of the time. Whether these are, means say for example, you were having a P in year 1 and you have given up the P, and at a later point of time you enter into certain similar kind of activities directly through the parent entity, then you can say that no, P and these direct activities are not linked. Proximity of the place, commonality of the purpose. So these are some of the principles which have been laid out, but not conclusive in individually. You have to see the circumstances in every case particularly and then decide what to be followed. Then this has to be seen that the issue 2 is where these activities are carried on. Means if you have permanent establishment in country A, then the similar business activities are also required to be carried on country A only. So for example, if parent entities doing certain business activities in country B, so those country B cannot be pulled on and taxed in country A just because of the force of attraction. So force of attraction rule is limited to the parameters or the physical boundaries of the contracting state in which that permanent establishment is located. So this is the issue 2. Now coming on to some examples, you would see that clause 7 1b is generally there for similar kind of goods or merchandise to be sold. This is there in Canada, New Zealand, Poland, Portugal, Spain, US. These entities, these countries have the treaties with India. You will find clause 1b. In Canada, clause 1B itself encompasses similar business activities also. But in other treaties such as Poland, Portugal, Spain, and US, there is another clause C. So there is a separate clause for similar business activities. So you can see what is there in each of the treaties and decide upon whether there is a force of attraction or not. In UK treaty, it is a very peculiar kind of a clause, which is not in Article 7.1, but it is a separate paragraph, Article 7.3, which says that profits of both directly or indirectly attributable to the PE, if the PE is actively involved in the negotiation and concluding of contracts. Now, what it is saying is that this is, somewhere merging the concept of agency P and the fixed place P. It is saying that if the P is engaged in negotiation of the contracts wherein the goods are supplied directly by the parent entity, then some part of the profits of the supply should be taxed in the hands of the permanent establishment and should be attributed to the profits of permanent establishment. So this is a very unique kind of a clause, which in any case should have been covered, but I'm not sure why this has been mentioned. But it has been mentioned, so we must consider it while deciding upon the cases. Now, this is one case law which is of SNC level, and it's an old case law of 2007. It is a Canadian company which was, which got one single contract from Chamera hydroelectrical project for planning, designing, engineering, and installation of a project of a hydro project in India. Now, planning and design was conducted by SNC Levelin, whereas the installation and testing and commissioning was undertaken by the project office, which was constituted in India. Now, in this particular case, the Delhi tribunal held that there is a force of attraction rule there in Indian Canadian double taxation avoidance agreement, and because of that agreement, the last activity, the last clause, which was C clause, similar business activities, they said that the project office and the foreign parent entity are engaged in the similar activity related to a same project. So therefore, even though the parent entity has directly rendered certain services to the project, the Chamera hydro project, but because there is a P situated in India, force of attraction rule will apply, and the entire profits of the project will be liable to tax in India. So this is one case, SNC Levelin. Then there is another case of Roxon OY. This is almost similar kind of a thing, wherein the supply of equipment was to be made to Nhava Sheva Port Trust, NSPT. In this particular case, what was happening is that the supply of equipment was to happen first, and then the installation P will be constituted by virtue of employees coming to India for installation and commissioning, which would continue for a sustainable period of time, so as to constitute an installation P. Now, in this particular case, the Mumbai tribunal held that because the supply of equipment has already taken place before the P came into existence, and also the business activities were different. Therefore, we cannot say that the force of attraction rule will apply, even though Finland treaty has a force of attraction rule. Even then, the Mumbai tribunal held that the force of attraction rule will not be triggered because supply of equipment had already taken place prior to the installation P coming into existence. Also, the activities of the two were different. One was supplying goods, whereas the P was rendering services. So therefore, on both the accounts, proximity of time as well as the nature of business activities, it was held that there will be no P of Roxon OY in India by virtue of force of attraction rule. I hope I am clear till now. Any queries? I think there is no query as of now, so we'll move forward. Now, there are a few other aspects also which are related to the Article 7. Now, Article 7.2 of OECD Model Convention and Article 7.2 of UN Model Convention, they are same. But there is says that how the P has to be taxed. The P has to be considered as a separate taxable entity. even though P is not a separate legal entity most of the times, wherein there is a big permanent establishment or the office, or we say in general sense that P is a virtual extension of the foreign enterprise onto the land of the source state. Although they might be same legal entity, but for tax purposes, you have to consider them as separate and distinct taxable entities. So you'll have to see that what would have been the case, what would have been the profits attributable to the permanent establishment if it was acting as a separate legal entity and a separate taxable entity, what arm's length kind of a profits it would have been earning. Those are the profits which were attributable. And how it has to be determined? OECD Model Convention says that taking into account the functions performed, assets used, and risks assumed. Now, this is what? These are the principles of transfer pricing. So, by applying the principles of transfer pricing, you will determine the profits attributable to the permanent establishment. Whereas in OECD, in UN Model Convention, it is not so clearly mentioned, but it is proximate to that only. Engaged in similar or same activities under the same or similar conditions and dealing wholly independently with the enterprise of which it is a permanent establishment. Means how you have to calculate the profits attributable to P? By considering that the P is a distinct and separate enterprise engaged in same or similar activities under the same or similar conditions and dealing wholly independently with the enterprise. This is also, in other words, the principles of transfer pricing only, right? And how the profits have to be attributed? There are various rules. There are Rule 10 in Indian Income Tax Act. There are in the income tax rules. There are other principles of attribution. The general principles of transfer pricing will apply, and you will calculate the profits taxable in the hands of the permanent establishment. Then moving on to the next paragraph, it is Article 7.3. Now, in OECD model, this paragraph does not exist. So therefore, in Article 7, there are different paragraphs. They are not identical in OECD Model Convention and UN Model Convention. So therefore, this paragraph is only in UN Model Convention, and therefore I have mentioned it. And you would find this paragraph mostly in all the treaties of India. What does it say is that while computing the taxable profits of India, you will allow deduction of certain expenses which have been incurred by the permanent establishment or by the parent company if it is in general administrative, executive or general administrative expenses so incurred, whether in the state in which the permanent establishment is situated, means the source state, or elsewhere. Means even if the parent company, parent enterprise incurs certain expenses on behalf of the permanent establishment, either in the source state or in the in any other state, those expenses will have to be allowed as deductible expenses. However, it also provides certain exclusions. What does it say? However, no such deduction shall be allowed in respect of any amounts paid by the PE to the head office. What it is restricting is that you cannot build in certain artificial expenditure into the books of permanent establishment. Now, permanent establishment, if it pays to the head office certain kind of expenditure, what are those expenditure? Royalties, fees, or other similar payments in return for the use of patents or other rights, or by way of commission or specific services performed, or for management, or except in banking cases by way of interest on monies lent to the permanent establishment. Means head office cannot lend its brand name or any technology for an exchange of royalty, or for any fees, or for any other similar payments, means for the use of patents or any other things, right? Or any other rights. Means if parent company has some right which it has to give it to the permanent establishment, what this paragraph says that it has to give it free of cost, or if the parent company lends a certain amount of money to the permanent establishment, even the permanent establishment cannot claim the deduction of the interest amount. Now, in the Indian context, probably we may say that the ECB regulations might come into picture, and parent company might not even be able to lend to a P or the project office, because ultimately the project office or the branch offices are running out of the money given by the parent office only. But in other circumstances, if you are dealing with other treaties or two other different treaties, you may encounter these cases also. Likewise, it goes on to further says, no account shall be taken in determination of the profits of a permanent establishment for the amounts charged by PE to the head office of the enterprise or any of its other offices by way of royalties. Means, say for example, what it says is otherwise also, means if PE charges certain royalty from the head office, then that will also not become taxable in India. Now we'll have to see what is the language in the Indian treaties. Probably this the last line, which is likewise no account shall be taken. This is generally not there in the Indian treaties. Moreover, you will find in the specific articles of Article 12 royalties, FTS or interest, where it says that if any royalty is effectively connected to the PE, it shall be taxable in as the income of the PE itself. So therefore, we need to see carefully what the Indian treaty, which the specific treaty which you are dealing with, says in that paragraph. Now, this is a case where India-UK DT I have mentioned. Now, you will see that there are two paragraphs and there are different things which are mentioned there. First paragraph is Article 7.5, which says that subject to the provisions of 6 and 7, in determination of profits, there shall be allowed deduction of expenses which are incurred for the purposes of business of PE, including executive and general administrative expenses, whether in the state in which PE is situated or elsewhere, which are allowed under the provisions of and subject to the limitations of the domestic tax law of the contracting state in which the PE is situated. So in the Indian context, you will see that there is a section in Indian domestic tax law which is 44C, which puts certain restrictions on the deduction of head office expenses in the nature of executive and general administrative expenses. And it says that more than 5% of expenses will not be allowed as deduction. So we'll need to see in each and every treaty whether these kind of limitations have been put on or not. And even if there are not limitations, subject to limitations is not mentioned, but it even says that which are allowed under the provisions of the domestic tax law. Even then, we'll have to come back to the domestic tax law for the allowability of certain expenditure. And when we are looking at the domestic tax law, 44C comes into picture, and we'll have to see whether the head office expenses will be allowed in all extent or whether they will need to be limited to the percentage of 5%. So one must also be very careful in seeing that what is executive and general administrative expenses. So these are general expenses, say for example, some cost reimbursements or some expenses which have been incurred by the parent company in running the show of the permanent establishment. So those kind of expenses may not be incurred, may not be chargeable in full extent. But say for example, if permanent establishment, the business of permanent establishment required certain technical services to be provided by a third party, and that third party has been paid up by the parent entity. Now in that case, probably you might not be able to say that this is general executive or administrative expense. This is a specific expense for the purposes of running of the business of the permanent establishment. In those circumstances, we'll need to see to what extent section 44C will apply. Now moving on to paragraph 7, what does it say? Paragraph 5 of this article shall not apply, means the deduction will not be available to the amounts, if any paid by P to the head office of the enterprise or any of the other offices by way of royalties, fees or other similar payments. So what it mentions is a similar clause which was mentioned there in the UN Model Convention, but what India-UK treaty has done is that it has bifurcated these provisions into two, right? So they have mentioned these paragraphs, these provisions in two paragraphs, Article 5 and Article 7. In this particular treaty, nor shall account be taken in determination of profits of a PE of the amounts charged by the PE of head office of the enterprise or any of his offices. Means this is in totality the UN model has been copied. Means neither the expense incurred by PE shall be considered, nor any income earned by PE in relation to fees, royalties or other similar payments earned from the head office. Please remember that this is only related to the head office. Now there can be a trade-off also, wherein we can see that Article 12 or Article 11 says that if it is effectively connected to the P, then you may tax it. But what it says is that neither you can incur expenses towards yourself, even though you are considered a separate separate taxable entity, but there is some limitation which has been provided that neither you should earn income from yourself, nor you should incur expenses towards yourself to certain limited items of revenue. So this is what Article 7.5 of India UK DTAA says. Now that was Article 7.5 of India UK treaty, but Article 7.5 of UN Model Treaty is principle of consistency, which says that once a method of attribution or once a method of calculation of profits of P has been adopted, then the same method will be adopted year on year, unless there is good and sufficient reason to the contrary. Means unless and until there is sufficient change in the business circumstances or business activities of the permanent establishment, the way and method of calculating the business profits or attribution of the business profits to the permanent establishment should remain same. And you will find almost invariably in all the treaties, you will find these kind of paragraphs. The paragraph numbering might be different, but you will find these paragraphs. Then the last paragraph says that where profits include items of income which are dealt with separately in other articles, then those items will not be covered under Article 7. Say for example, I mentioned royalties, fee for technical services, interest, other income, or any other source of which is business income, which is per se your business income, but has been treated as a particular item of income in a separate article, then you will not consider it under Article 7. So therefore, Article 7 is to cater to the generic business profits other than those specifically mentioned or dealt with in specific articles of the DTAA. So this is it from my side today, and I will be happy to answer your queries if you have some. I think today we have concluded right on time.
Sir, if a permanent establishment takes a external commercial borrowing for setting up of office and all, for which the head office has provided some counter guarantees in their country, can that banking charges claimable by the permanent establishment, or it is disallowed?
Now, to whom this permanent establishment will be paying those charges? To the parent company or to the third party?
Because the guarantees have been provided by the parent company.
Guarantee is not a material factor,
For
because
the charges of the guarantee, they have to pay in the source country. No? I mean, their country.
pay to whom? Pay to the parent company or pay to a third party?
To the third party, yes.
So the third party is there, then as per the UN Model Convention, it will not be covered.
Not covered. Okay.
It says na paid to a head office, paid to the head office. Now you are not paying to the head office.
Okay. Even if there's an arrangement is done by the parent company.
Right, sir.
Okay. Okay.
Who is the lender? See, you will see guarantee fee, cases of guarantee fee.
Yes.
Now, whether guarantee fee, because parent company, when it guarantees your debt, guarantee fee is charged generally by the parent company to the Indian company. Now, when the Indian company is paying that guarantee fee, a question invariably arises that whether this guarantee fee is in the nature of interest or not. And almost all the tribunal rulings have held that guarantee fee is not in the nature of interest, because the parent entity has not lent money to the Indian entity. The lender is someone else.
Okay. Even if without them, they could not have sourced the funds.
Yes, sir. Not an issue.
Okay. Thank you.
And also, if you would see, and I don't know, interest is covered or not. Interest, yes, interest is covered. Interest on money is lent to the permanent establishment, but the money has to be lent from the parent entity itself. See, for example, in the Indian context, you will see that external commercial borrowings do not permit, to my knowledge, in a project office kind of a situation, they do not allow even borrowing of funds through third party, because project offices or branch offices are generally restricted in a sense that they can be operated only through the monies remitted by the head office. Right. So I'm not sure, means in your particular case, whether it is a project office or a branch office, or you are saying that in case of a subsidiary company, the guarantee has been provided?
Yes. There's a parent and subsidiary, the guarantee.
So in a parent and a subsidiary, the subsidiary in itself does not constitute a P. So first of all, you'll have to see whether there is a P.
No, there is a P. Only thing is whether these charges are deductible.
What circumstances this subsidiary company is creating a P? Have you accepted it before the tax authorities?
Yeah, I just sent the case in. I'll just send it in WhatsApp.
Sure.
Thank you.
Anshul, we don't have any other question in chat box.
Great, G, great. I think.
Anshul,
Yes.
Manish Ji.
would you please elaborate on the recent case law of Supreme Court in the UAE exchange about
About
the PE?
Sir, I have not read that. Probably if you can send me the citation,
Okay.
I can read and explain in the next session.
Yeah.
In the WhatsApp group, you can share the citation. I'll check it. And
Manish, you can share in WhatsApp. We can take up in next session.
right, sir. Thank you
Right,
very much.
Anshul.
Thank you, sir. It was
Thank you,
very-
Piyush,
you,
for
Anshul.
coordinating the session. Thanks
Very good.
everyone for participation on the Sunday. Thank you. And
Thank
please do keep logging in. Probably I'm seeing that the participation is dropping, but let's keep participation up, and it will encourage the speakers also. Thank you very much, all of you.
Thank you, Anshul.
Bye.
Thank you so
Thank you,
much.
Anshul.
Thank you,
Thanks a
sir.
lot,
Thank you
Anshul.
everyone for
Thank
joining
you.
session.
Thank you, sir. It was so interesting. Thank you.
Thank you. Bye bye.